Marietta divorce modification lawyer divorce orders are designed to reflect the circumstances at the time of the divorce. But life changes, and when it does, the terms of child custody, child support, or alimony may no longer be fair or practical. In Georgia, the law allows for modifications under certain conditions, but these changes are not automatic. They require a legal process to prove that a significant shift has occurred. Whether you're seeking a modification or challenging one, understanding the legal framework is essential. The legal framework for divorce modifications in Georgia law provides a legal pathway for modifying divorce agreements when a material change in circumstances occurs. This means the person requesting the modification must show a significant life event that impacts the original terms of the divorce order. Family law judges in Cobb County assess these requests by considering financial changes, relocation, and the well-being of any children involved. For child custody modifications, a court must determine that the change benefits the child's best interests. If a parent is relocating, they must provide notice, and if the move significantly affects the existing arrangement, the other parent may challenge it. Child support modifications may be necessary when a parent's income changes significantly, whether due to job loss, a raise, or new financial obligations. Alimony can also be modified if either party experiences a major financial shift, and in some cases, it can be terminated if the recipient remarries or cohabitates with a new partner. Understanding Georgia law and presenting strong evidence is crucial in these cases. An experienced attorney can help navigate the legal process and advocate for a fair outcome. When can a divorce order be modified? Not every life change qualifies for a divorce modification. Courts require a substantial shift in circumstances to consider adjustments. Some of the most common reasons for modification requests include parental relocation. If a custodial parent moves a significant distance, it may impact visitation rights and require a new custody arrangement. Georgia law requires at least 30 days' notice before a move, giving the other parent time to object. Financial changes. A major increase or decrease in income, involuntary job loss, or new financial responsibilities, such as caring for another dependent, can justify modifications in child support or alimony. Changes in a child's needs. As children grow, their needs change. Increased educational expenses, medical issues, or other factors may require adjustments in child support payments. Cohabitation or remarriage. If an ex-spouse receiving alimony enters a new relationship and cohabitates with a partner, the paying spouse may request a modification or termination of alimony under Georgia law. Safety concerns. If there is evidence of abuse, neglect, or other risks to the child's well-being, a parent can request a custody modification to ensure the child's safety. These modifications require legal action, and courts will not make changes unless proper evidence is presented. Working with a lawyer ensures that all necessary documentation and arguments are in place. How does the modification process work? Modifying a divorce order in Cobb County involves several legal steps. The process typically begins with filing a petition demonstrating the substantial change in circumstances. This petition must include evidence supporting the request. Once filed, the other party is formally served and has the opportunity to respond. If both parties agree on the modification, they can submit a joint agreement for court approval. However, if there is a dispute, the case will proceed to a hearing where a judge will review the evidence and make a decision. For child custody modifications, courts prioritize the child's best interests by evaluating each parent's ability to provide a stable environment, their financial situation, and the child's overall well-being. Child support modifications follow Georgia's statutory guidelines and require proof of income changes or new financial responsibilities. Alimony adjustments depend on financial hardships, remarriage, or cohabitation. If a party fails to comply with an existing court order, they may face legal consequences, including contempt of court. This can result in fines, wage garnishments, or even jail time in extreme cases. Seeking an official modification through the courts is the only way to ensure compliance and avoid penalties. Get help with your divorce modification case if your divorce order no longer works for you. The legal team at Tori White Legal Group can help. Our attorneys understand the complexities of divorce modifications in Georgia and are committed to protecting your rights and interests. Whether you need to adjust child custody, child support, or alimony, we can guide you through the legal process and advocate for the best possible outcome. Call Tori White Legal Group today at 770-744-1529 or visit us at 274 Washington Avenue Northeast, Marietta, Georgia, 30060, United States to schedule a consultation. Let us help you take the next step toward securing the modifications you need.